And here with his thoughts on what's at stake, Jeff Brennan. He's the former healthcare services chief at the Federal Trade Commission, currently a partner at McDermott, Will, and Emory. Welcome, Jeff. You know, this is a complicated, somewhat gnarly set of rules that pertain in these cases. The simple question, I guess, is who's winning and who's losing here? Are consumers losing? Are drug companies winning? Or is it just not that simple?
It really isn't that simple. It really depends on your view about this paradigm which the FTC is challenging. The FTC would say, and its supporters would say, that in a settlement agreement in which the brand company, the innovator company, pays money to the generic, that has the effect of delaying generic competition. Generics enter the market at a lower price, and so the longer that takes, consumers are worse off because they don't have an option for a lower-priced alternative until a later time in the future. The opposite response to that by the parties who enter into these agreements is that the brand, one must remember, has a patent protecting some aspect of its drug product. In fact, these are patent infringement litigations that are getting settled, and patents convey a right to exclude competition lawfully. It's a fundamental aspect of our economy, and it helps support why innovator drug companies invest the R&D monies over a long period of time to develop new drugs, and that so long as the patent settlement agreement provides for generic competition before that patent expires, consumers are better off because they're getting competition sooner than they would if the patent ran its course.
But what happens, Jeff, if the FTC wins this case and everything has to go back to court? All the parties have to pay enormous costs, a lot of time to work through their differences. In the end, doesn't the consumer end up paying more money? Doesn't that increase the costs anyway?
Well, that could happen if drug companies need to spend more time in the courtroom paying people like me, attorneys, to litigate their cases. That raises their costs, certainly, and costs, as we all know, in a market economy, ultimately at some point and at some level get passed along to consumers. So from that perspective, certainly the drug companies would point out, as you mentioned, that a rule that had a tendency to extend litigation rather than help terminate litigation and move on have costs for consumers that need to be taken into account.
So the FCC basically says if these lawsuits proceeded, in other words, the generic company that's suing to overturn a patent, if they proceeded, then the consumer might get those generics sooner than they otherwise would. The branded drug people say, well, we're doing a deal where we're going to bring generics or allow generics in return for a fee to come to a market sooner than our patent would allow if we were to prevail on the patent case. I guess what stands out to consumers would be the idea that there is something that sounds vaguely anti-competitive about one company paying another company a fee, quote, not to compete. Have I got that right?
You've described that quite well, the situation. I mean, I think one thing that's worth keeping in mind, these are not, as one of my former colleagues once said, it's not a bag of cash that's being handed surreptitiously from the brand to the generic. These are in connection with ancillary agreements in the settlement agreement that have their own stand on their own two legs, if you will. A co-promotion agreement with the generic drug company to promote the product to, in this case, urologists, a joint development agreement, a joint venture to develop a new innovative product, a supply agreement, things of that nature. So this isn't just cold cash going from one side to the other, but it's in conjunction with other arm's-length transactions.
Very quickly, decision on this expected when? June, end of the term?
Most likely end of the term. You know, we could be surprised, but I think most people are thinking about June.
Jeff Brennan, former head of the FTC's Healthcare Services Division. Thanks for being with us.